You may not believe this, but I actually had to travel to the future to iron out all the problems with the Illinois cannabis dispensary license application. A special legislation clause of the Illinois Constitution may actually come into to play, and you might not know what the special legislation clause of the Illinois Constitution is, and that's all right. A lot of people don't, but it may actually blow up the not the enterprise, but it may blow up the license lottery, and it might allow everybody who's a social equity applicant and got a perfect score to be into the lottery, as opposed to just social equity veterans to be into the lottery. And so we're going to dive all into special legislation clauses on the Illinois Constitution, and of course we do that here because it's the thing that we like to do on a very special episode. Oh, okay, that's right. And because we're going to be talking about some case law, and this is going to go into and be one of the lessons in the course, how to appeal your cannabis license denial in Illinois. This one is about well, we already mentioned it. It's about a special legislation, and there was a lawsuit that was filed approximately 5 days ago in Sangamon County, whose venue is appropriate because the people at Lock Lord actually read the laws. And so what they've raised, though, is a case that is fascinating, and this stuff hasn't come up very much. You might not know and that's a different one. You might not know what a special legislation clause is. A special legislation clause is one of the reasons why there's no such thing as tort reform, really, in Illinois, and mostly because damage caps on personal injury cases violated the special legislation clause. And so the Illinois Constitution provides the General Assembly shall pass no law or no special or local law when a general law is or can be made applicable. Whether a general law is or can be made applicable shall be a matter for judicial determination. And so in our Bill of Rights, Amendment 13, I guess it said, well, no, this is in the special legislation clause. It essentially means that you're not allowed to have laws that create two different classes for no real good reason. The seminal work on this is the Best versus Taylor Machine Works case from the Illinois Supreme Court back in the mid to late 90s. I want to say it was 1998. And these types of clauses may apply to the veteran points in Illinois cannabis. And so because it might apply to the veteran points in Illinois cannabis, that might knock out the veteran points, which was only 2% of the score, but because of the way they did it, it actually turned out to be 100% of the winners. Veterans are, of course, only about 6 to 7% of the population of the state of Illinois. To create a legislation that treats them specially and gives them additional points so that they are the only ones who comprise the ownership of the dispensary licenses may be considered a special legislation. And of course, there are some examples in this special legislation, and a lot of it has to get back to the malpractice limits that they have. And so what types of things can special legislation get into? It is when, well, there's a problem with being live. I didn't have any notes. I've had a day. Okay, so the special legislation clause expressly prohibits the General Assembly from conferring a special benefit or exclusive privilege on a person or group of people because to the exclusion of others similarly situated. So, for example, not everybody can be a veteran. I'm sorry, you may be 4F. I'm not sure if they still call it 4F, but you might just not be able to become, you might not be able to serve for religious reasons, for physical reasons, for whatever reason. And so it confers this special distinction on veterans and gives people additional points, which then led to 100% of the winners being quote unquote veterans. And so the court, and that's the Illinois Supreme Court, said that the purpose of the special legislation clause is to prevent arbitrary legislative classifications that discriminate in favor of a select group without a sound, reasonable basis. And so now, if the state of Illinois can defend against this case, which again was filed in Sangamon County, let me pop it back up there. There's the complaint. I'll zoom myself out a little bit. And so it's a complaint for injunctive relief and other relief, which is kind of what you do. Like that's, if you guys want my help on filing your lawsuit, please do hit me up at tom@collateralbase.com. That's kind of what we entitle our complaint, except we call it a verified complaint. Ask me what a verified complaint is. I'd love to tell you. And of course, this will also be included in our lesson on how to appeal your case. If you want to get this, if you want to audit this case for free, or this course for free, the link is in the description. You can head over there, and this new lesson on the special what privilege? The special legislation lesson will be added as well. And these types of special legislations, they have been used to strike down all sorts of things, not necessarily just malpractice damage awards caps, but other things. You know, they've invalidated discriminatory classifications of employers, employees, and third-party tortfeasors and workers' comp provisions. Yeah, a lot of it has been regarding the medical malpractice aspects for these types of special laws. But the distinction between special and local laws could be as follows. It says, a local law is one which only applies to the government of a portion of the territory of the state, and a special law is one that applies only to a portion of the state, its people, its institutions, its economy, in some sense other than geographical. And so it's not necessarily a local law that says veterans in a particular locality. It's a state license. And so because they are treating veterans differently than they are treating other social equity applicants, they are going to challenge the constitutionality of that. Like I said, in this course, how to appeal your cannabis license denial. And if you want that, hit this up, because I'm going to take this down from my most popular YouTube channel, Cannabis Legalization News. It'll still be on my law firm's YouTube channel, Collateral Base. You can head over there and subscribe to that if you would like. And that's where we're going to really just kind of house this, mostly because it really is a legislative aspect, which I don't think a lot of people are doing YouTubes on special legislation and special legislation cases like this particular case, the Best v. Taylor Machine Works case. And so, this type of special legislation goes back. I mean, back all the way until 1870 when they had it. And they actually made a distinction in the Constitution itself. And so this special legislation has been used primarily to attack tort reform. And it's actually the special legislation challenge is judged under the same such standards as an equal protection challenge, because it kind of sounds like an equal protection challenge. It might just be Illinois' variant of an equal protection challenge. And it's fascinating. Now, it's going to hopefully not be met with it will be met with a motion to dismiss. Most lawsuits are always met with a motion to dismiss. It'll be interesting to see if this actually is persuasive and it makes it past this stage. And it says, if it does not affect fundamental rights or involve a suspect or quasi-suspect classification, then it just needs rational basis review. So provided that the state of Illinois had a rational basis for awarding veterans an extra 2% of its score, then it will not be found to be invalid. However, if there is no rational basis for awarding an additional 2% of the score to veterans under the CRTA, the Cannabis Regulation and Tax Act in Illinois, then that would be stricken, and so the veteran points would go out the window, and suddenly the floodgates for how many people should be in the lottery opens up, and it would probably be more than half of the teams that applied, which would be fascinating. And so, again, I had to go to the future. Here I am in the deck at the Starship Enterprise, trying to explain what happened in the past because of all the weird, crazy stuff that happens in Illinois' cannabis. It is not just Illinois' cannabis. Any state that has a cannabis licensing regime like Illinois, where you are trying to make it merit-based, where somebody gets a score and there's only a finite number of licenses, this type of cluster always happens. We're still looking for people to get their scores. If you'd like to learn how to get your scores, do email me at tom@collateralbase.com. And then you can head over to my website. The big website that I have is cannabisindustrylawyer.com. It's my blog where I blog about all the things cannabis industry, and I'm starting to offer courses there so that I can help people get into the cannabis industry at a better price and understand what they're getting into. And so this course right now, I've discounted it to $500. but it'll walk you through the type of lawsuit that I think you should file, the type of lawsuits that have been filed. Stick around for another one of these episodes because I'm going to do it once I understand what the state of Illinois files today. I suspect a motion to dismiss is forthcoming in the federal court action, mostly because we're going to be discussing due process rights and what a vested property interest is under due process rights to determine whether or not the federal case will be dismissed. And that would just leave state actions that are very often also predicated on these due process rights. There's actually a distinction between the two types of licenses, and so the dispensary licenses have different language in it for when you should get a 10-day notice and scoring procedures than the Department of Agriculture, your grower licenses. There may be different types of due process and the rights that you have depending on what type of license you're getting. Yes, I know that can be complex and convoluted. So please do head on over to our website, cannabisindustrylawyer.com/courses, and you could find this course on how to appeal your cannabis license denial in Illinois. Maryland is kind of similar to Illinois, to be honest, with what they've been going through. So we're going to have to see how this all turns out. Anyway, tomorrow at 2 p.m., you know what it's going to be. And I hope to see you there. Don't forget to hit the likes and the subscribes.